So Hong Kong is full of paradoxes today. Hong Kong was considered as a former British colony from 1942 to 1997 under the British colonial rule, and since 1997, Hong Kong's sovereignty was transferred to the People's Republic of China as a special administrative region. I guess this picture accurately captures the tensions between Hong Kong and China over the legal domain. On the one hand, you can see this is a statue, the Lady Justice on the former Supreme Court in Hong Kong, we call the Court of Final Appeal, which is a common symbol to show the importance of justice and equity in a common law regime that Hong Kong has been inherited from the English common law system for many decades. But at the backdrop, you can see that is the Bank of China. Actually, geographically speaking, this is accurate because the location of the former Court of Final Appeal in Hong Kong was exactly just beside the Bank of China in the Central District. And this book is mainly trying to articulate or unravel the tensions between Hong Kong and China over the legal and judicial domains. And in particular, my book tried to study two questions. Why and how is the rule of law in Hong Kong at stake under the Chinese sovereign state? This may be a very contested research question because people could argue there, as I will also explain in the following presentations. The erosion of the rule of law in Hong Kong, or the so-called erosion or deterioration of the rule of law in Hong Kong, was attributed not just by the Chinese rule, but also there are roots under the British colonial administrations. But amid all the disputes and the concepts, the second part of my book tried to explain how have lawyers, as one of the key actors in the legal systems, defended the rule of law in post-colonial Hong Kong under the Chinese rule. My book sounds a little bit not conventional to the mainstream legal scholarships because most of the legal scholarship study case law. Verdicts is more doctrinal. But my book is more socio-legal and a lot more qualitative method to try to study the behaviors of lawyers, former judges, legal academics, and legal activists in Hong Kong between 2018 to 2020, immediately after China's imposition of the national security law. So perhaps if we pause here, one may ask, is Hong Kong's rule of law really at stake? Is Hong Kong's rule of law being eroded in the past decades? I guess if I may quote some of the existing literatures and findings, many observers, analysts will suggest that Hong Kong has enjoyed a robust rule of law system for many decades, especially ever since the British colonial rule. We have a robust independent court. We have a strong legal profession trained both by the local law schools and the English common law traditions. And we also have a very competent civil society that would encourage and promote judicial independence and basic rights protections, even at the very beginning of Hong Kong's handover to China. And one of the major twists that was observed by many policymakers and analysts was 2020, when Beijing imposed a national security law on Hong Kong. And many observers, foreign government statements, NGOs repeatedly argue that the imposition of a draconian national security law in Hong Kong almost swept all the political oppositions, jeopardized freedom of speech, jeopardized freedom of expressions, and undermine the judicial independence. But in my book, I guess one of my major arguments in this book is trying to explain that even before 2020's Beijing's imposition of the security law, Hong Kong's rule of law has already been in danger. It's not just because of the China factor or China's interference into the domestic affairs in Hong Kong, but also there are infrastructures rooted during the British colonial times that enabled the Chinese regime to further erode the legal systems in Hong Kong. And other questions probably about what do we mean by the rule of law is always a contested concept, and different concepts try to lead us to different trajectories of the idea of the rule of law. And here in this book, rule of law is a concept that contrasts mainly rule by man. Rule of law respects separations of powers, protections of fundamental rights and freedoms, and to limit the government to prevent any power abuses. And contrasting this concept of rule of law is, of course, rule by law, or fundamentally rule by man, that rulers, political authorities enjoy discretionary powers to centralize their authorities and powers from any forms of checks and balances, and this centralization of power is a form of autocratizing a regime. And this is quite common in today's world where countries underwent democratic backsliding or autocratizations, even in Western democracies. But apart from that, I guess my book is trying to think about how do we defend the rule of law. And for many scholars in post-conflict studies, they would suggest that to defend the rule of law does not only mean to defend the rule of law institutions. We have courts, we have law enforcement, we have prosecutions, we have legal aid system. These are important institutions, but more importantly, you need the general public to enjoy the shared values of the rule of law, a cultural norms that respect each other's rights, that respect separations of powers, that acknowledges the importance of limiting government power to prevent power abuses. So in a way, to defend the rule of law in my book is not simply about defending the legal infrastructure, but also to cultivate and to promote norms that support the ideas of the rule of law. This is the reasons why I study lawyers, especially activist lawyers in Hong Kong. Back to the main case study of this book is Hong Kong. As I mentioned at the very beginning, Hong Kong is full of paradox. In the first place, it's not a sovereign state. It's not a sovereign state. It doesn't enjoy a sovereignty, but it has been given a high degree of autonomy under the Chinese Communist regime. But on the other hand, Hong Kong does not operate a system like in the mainland. It doesn't operate a socialist legal system, but rather it has its own common law system. It has its market economy, which is different from the planned economy in the mainland China for decades. And Hong Kong operates its own executive administrative system that's unlike in how the party state works in the mainland. And this arrangement was considered as one country, two system formula. And that was agreed as early as in 1984 when the Chinese authorities and the British government agreed under a joint declaration. And in 1991, the Chinese government promulgated a basic law for Hong Kong before its handover. And this basic law is a fundamental document to try to formulate the constitutional order in Hong Kong and is Hong Kong's relations with China. But if we go much more deeper from a historical perspective, Hong Kong's one country, two system was not something new. It is not so exceptional if we read how the Chinese Communist Party tried to govern China's periphery as early as 1950s. This picture refers to the 17 agreements between the CCP, between the People's Republic of China and the Tibetan community led by Dalai Lama in early 1950s. And under that arrangement, the CCP also promised that the Tibetan community could enjoy a high degree of autonomy as long as they belong to the one family of Chinese people and to allow the central government to handle diplomatic affairs and national defense, etc. So this was the origin of CCP's one country, multiple system model. But if we go further, why would Beijing impose this idea of one country, multiple system? It's also not something new. Recent scholarships on Hong Kong-China relations discovered actually the arrangement of one country, two systems in Hong Kong was something sourced from how the Qing dynasty, how the Qing emperor governed its ethnic minorities in the peripheral regions. For example, like Hong Ho Feng, as well as legal scholar Paul Harris, and even for mainland scholar like Jiang Shigong, who is also kind of official scholars in the mainland, they argue that the Chinese Communist Party would want to find sources of legitimacy, not just by its own performance, not just by its cultivating nationalism in the country, but also trying to find sources in his prehistorical context. That is, they are trying to adopt the Qing dynasty's model of a central peripheral governance. And that's why in Hong Ho Feng's book, City on Ash, he suggested that a one country, two system formula is part of a China's political agenda that's an empire pretending to be a nation state. It is the Chinese Communist regime's ambition to try to model the empire building process, to expand its governance to the peripheral regions, and eventually this one country, multiple system model was a pragmatic and transitional arrangement because eventually they would want to absorb these peripheral communities into its own mainland socialist and communist system at all. For Hong Kong, it is very convenient for the Chinese regime to do so because Hong Kong has been undergoing two waves of legal transplantations. For studies in law and colonialism, transplantation is a typical method for the colonizers to impose new policy, infrastructures, legal statutes, and legal system to the colonized people as a way to expand its influence and to justify its governance. And in many scholarships, legal transplantations, the context of colonialism is also equivalent to the idea of legal imposition, or even some would say it's a form of legal imperialism. Putting aside the academic jargons is simply showing how colonizers will try to transplant its system to the colonized subjects. In Hong Kong, it has undergone two waves of this transplantation because at first, Hong Kong was a former British colonial regime and the British government has already transplanted its common law legal system into Hong Kong. On top of that, the British ruler did not simply transplant the common law systems in London, but rather they are also transplanting draconian rules and legal statutes from other British colonies in order to enhance their capacity to suppress anti-colonial movements in Hong Kong. For example, in the colonial history of Hong Kong, there was a public order law, and this law was used to target anti-colonial activists ever since 1960s. And this law was adapted or transplanted from Malawi. Malawi is another former British colony at the time. When I said Hong Kong underwent two waves of a legal transplantation, and actually it's not just for the British regime, because after 1997, most of these draconian legal instruments were not abandoned or abolished or repealed, but rather they were reserved and even enhanced by the post-colonial Chinese administrations in Hong Kong, or the SAR, the Special Administrative Regions government. And the public order law I just mentioned were heavily used in the 2019 protests. I guess some of you have heard of the anti-extradition protest in 2019, a 6-month-long decentralized protest across the city of Hong Kong. Because of the enforcement of this law, more than 10,000 people got arrested in Hong Kong and nearly 3,000 of citizens got charged and faced criminal trials, and some of them were sentenced to jail for years. And we can see this is a kind of how legal transplantation worked in Hong Kong. Hong Kong underwent the transplantation from the British colonial regime, and under the post-colonial regime since 1997, the Chinese communist regime and the Hong Kong government continue these colonial legacies to try to suppress anti-authoritarian movements in Hong Kong. And in this sense, we can say Hong Kong's one country, two system was not how some mainland officials or mainland scholars suggested. Is the opening of Hong Kong's decolonization from the British imperialism, but rather the one country, two system setting was to freeze the pre-existing infrastructures in Hong Kong that to allow the new government to try to use these colonial legacies to enhance its rule. But to do so, the governments could not work alone. They need allies. And therefore, in this book, I try to explain, well, on the one hand, the Chinese and Hong Kong authorities would want to impose want to transplant or impose their authoritarian legal norms and practices into Hong Kong. But on the other hand, they have also been taking years of work to try to build allies in Hong Kong, to try to build allies who can justify, rationalize, and support all this transplantation work in the legal domain. And that is building allies with the lawyers, and a common concept pop up, that is the United Front. And since for many decades, the Chinese Communist Party, even before the handover in 1997, has been building allies by co-opting with local legal elites to prepare for the handover. And this diagram was adapted from an excellent scholar in Taiwan, Wu Jianmin, where he tried to explain how China factor works in Taiwan. And there are direct mechanisms and indirect mechanisms. And of course, the Chinese regime could directly impose new norms, statutes, and ideologies into Hong Kong in the legal domain. Well, one obvious example is the imposition of the national security law in 2020. But on the other hand, they also need allies. That's why they need to build allies with lawyers through the United Front's work. And how can they do this? United Front is a specific way for the Chinese Communist Party to co-opt with elites that may not have a strong ideological propositions, but to be willing to co-opt with the government in order to strengthen the alliance of governance. And this is also another way to try to sideline or marginalize the dissent in different sectors in a way and ensure the communist rule is stabilized in this sense. And in the case of Hong Kong, China has been using multiple efforts to try to build allies with the legal community, especially when the legal community has been well trained by the British common law traditions, and many of them have a strong ethos in liberal democracies. We have seen in the past many Hong Kong pro-democracy figures or opposition leaders were legal professionals, including Martin Lee, Albert Ho, Margaret Ng. They were famous as a politician as well as outstanding lawyers. For the regime, they need to build parallels. They need to have parallel supporters, especially when they have to justify their interventions in the legal and constitutional affairs in Hong Kong. By doing so, they are using both political and economic incentives. Political incentives refers to encouraging them to be political appointees of Beijing, such as being appointed as a political consultant, or to invite them to run political elections as a ways to enhance their popularity and influences in public debate. But more importantly is to build economic incentives. As I mentioned at the very beginning, Hong Kong operates a separate legal system from mainland. All of the lawyers in Hong Kong are practicing common law. And for lawyers in the mainland, they are using the socialist civil law system. It's a completely different ways of doing lawyering in two places. But since 2004, the Chinese government attempted to open the legal service market for Hong Kong lawyers in mainland under the close economic partnership agreement that is called CEPA, C-E-P-A. Under this agreement, and after that, both Hong Kong and Chinese authorities opened the legal service market for legal professionals of both sides, and to try to create so-called economic prosperity of the legal community, both for solicitors and for barristers. Following the English tradition, barristers were seen as mainly tackling contentious legal work, let's say litigations, providing legal advice. For solicitors, it's more for non-contentious work, such as helping companies to set up their IPOs or to set up their companies' registrations in Hong Kong, etc. More civil matters or a criminal defense. In cases. But in mainland, it doesn't have this distinction between barristers and solicitors. So how could it work? Because of the opening of both legal service markets in Hong Kong and China, actually now the Hong Kong market allows mainland lawyers to set up law firms in Hong Kong through partnerships or other arrangements, and they are considered as part of the foreign law firms in Hong Kong. And in the past 2 decades, you can see the black bars are law firms operated by lawyers from the mainland, and there's a growing tendency of mainland law firms are set up in Hong Kong as part of the foreign law firms. At the same time, after 2004, under China's economic favorable policies on Hong Kong, there are a lot of mainland listed companies setting up, engaging in the local equity market, the stock market. And by 2019, more than 50% of the mainland companies, of the companies listed on the equity market are sourced from mainland. What does it imply to the legal community? This is a big business because many solicitors would need to mainly run their business by helping companies to be listed on the equity markets, setting up IPO initial public offerings as well as other paperwork, and this is a huge market for the legal community to be engaged in. You can see, and from the other figures that I put in the book, by 2019, more than 70% of the market capitalization of mainland enterprises happened in the equity market. So mainland capital becomes a prominent economic incentives for law firms, legal chambers to consider mainland clients are their main sources of income. Because of this economic development, some lawyers that I interviewed also expressed their anxiety and their fear in expressing their views or contesting against the political authorities' intervention to the legal system. And here I may quote, "My feeling is that many lawyers were unable to exercise free expressions in Hong Kong because there were times when my colleagues and I were asked to join a silent march in defense, showing support for judicial independence and the rule of law. But most of the clients of the international law firm came from China. And even though I have my own opinion on some matters in politics, I don't have the guts to share my views in the law firms where all my colleagues are mainland Chinese. And that is how a solicitor worked in foreign law firms in Hong Kong explained. And under these economic structures of the legal service market in Hong Kong, politics and economy were blurred, or they become integrated. The heavy dependence on the mainland legal service market will also make mainland authorities and political forces within the establishment be more able to reach out to junior lawyers to ask them to support any political agenda. And here another one quote, another interviewee explained, when a pro-government opinion leader began to collect signatures against Hong Kong civil disobedience movements back in 2014, I was told by some delivery boys who were rank and file officers in the firm that they were asked by that partner to sign their names on a statement against Occupy Central. Occupy Central was a pro-democracy initiative asking for universal suffrage even at the expense of their own liberty because they were engaged in civil disobedience as a way to try to pressurize the government. So at that time, pro-government forces are trying to build allies and coalition to fight against these pro-democracy initiatives, and they're trying to collect signatures from different sectors, especially for lawyers. As they are arguing, lawyers should tell the society they should be obeyed to the law. They should not accept any forms of civil disobedience that is contravening our understanding of the rule of law. And these junior lawyers, they may not support this idea fully, but under the economic and political pressure, they have to comply. They have to give their names to their law firm partners, to their bosses. So that is probably the first half of my book. So what do we mean by legal resistance? Back to the title of my book, Legal Resistance Under Authoritarianism. For many academic scholarships, especially in American literature, there is a very famous concept or famous studies on cost lawyering. I guess it's a really American exceptional ideas. Lawyers are not simply working for the needs and the best interests of the clients, but also sometimes they will act out of the moral causes that they believe in. So that's how cost lawyers was conceptualized generally. And there was also another strand of literature on legal mobilization, like how lawyers mobilize their resources to fight for human rights cases, fights for a cause in the courtroom, in litigations, in judicial reviews. That's what's happening in the US right now, right? But for my book, most of the methods for lawyers' resistance to this legal transplantation or legal imposition happen beyond the courtroom, mainly because of two reasons. First of all, most of the erosions of the rule of law or the challenges to the local common law system came from external factors, as I demonstrated. It's mainly by China's legal imposition or legal transplantations, and all these processes happen outside of the courtroom. The judiciary, the court has no say to tell Beijing you should not do it, or we accept it or not. It is interventions to the whole ecosystem of the rule of law in Hong Kong, rather than things happening inside the judiciary. And second, these forms of resistance are mainly aimed to mobilize the public support for a liberal conception of the rule of law, as well as to challenge some conventional understanding of the rule of law. And as I demonstrate later on, most of these resistance are not simply try to promote a rights-based understanding of the rule of law, but they will also promote the ideas of access to justice, especially in many criminal justice systems in Hong Kong. And most of all, to defend professional autonomy of the legal professionals. It is not simply about the integrity of the legal system, but also to uphold the integrity of the professional community free from political and economic coercion driven by the Chinese regime. And this also echo at the very beginning when I tried to use the idea of legal transplantation as a form of a legal imperialism or colonialism. And when there is domination or imposition, it's always resistance. And we can find all these instances in colonial and post-colonial studies. Eventually, decolonization struggle was a typical response to legal impositions by colonizers in many historical instances. And people either accept the repressive norms or they resist it, and eventually this led to these paved ways or laid foundations for decolonization movement of those former colonies in historical sense. So what do I mean by legal resistance then is the book mainly studies three types of methods of resistance. for a group of lawyers in Hong Kong. In Hong Kong, on average, there are 1,500 to 2,000 barristers, 15,000 to 20,000 solicitors in Hong Kong. And for my study, I was studying activist lawyers in Hong Kong, meaning that these lawyers are trying to engage in public affairs, in engaging in defense of the rule of law ideals and judicial independence, rights protections by activist means. And what are these activist means? First, they will engage in forming civil organizations to try to support civil society in litigations, in criminal defense, as well as promoting basic legal knowledge for protesters. I guess it's similar work like ACLU here, but these groups do not have a capacity to engage direct litigation. It's more like public legal educations, especially for building capacity for civil society groups in Hong Kong. And the second method is about legal assistance for protesters. It's really to recruit and to form teams of pro bono lawyers to try to engage in criminal arrests against protesters. Especially, it's not just in 2019 in the famous anti-extradition protest. This engagement with criminally arrested protesters has emerged as early as in 2005, when Hong Kong held the WTO conference, where farmers from Korea went to Hong Kong to fight against neoliberal policies imposed by the WTO. It also happens in 2014. So by engaging with protesters is a way for the lawyers to realize the importance of access to justice, as well as to engage, providing actual support for protesters in Hong Kong. And one example is that I'm not sure how the criminal justice system works in all the states here, but in Hong Kong, if you got criminally arrested, you will not have any pro bono lawyers stationed in police stations. Therefore, you can only find your own lawyers to witness your conversation with the police, to give testimonies, etc. So this is a loophole of the whole criminal justice system process, because you do not have pro bono lawyers or duty lawyers in the police station that to ensure the whole process were due and fair. So this is how the pro bono lawyers engage in all these protests or post-protest support for protesters. And thirdly is leadership contestation. When I refers to contesting leadership within the professional bodies. In Hong Kong, the Bar Association governs the barristers, where the Law Society governs solicitors in Hong Kong. When I explain the political and economic factors that help the legal transplantation processes, actually both professional bodies played a pivotal role, because they have also heavily engaged in building economic relationships with in the mainland service market. On the one hand, it could help lawyers to expand their business opportunities in the mainland, but on the other hand, it is also a trap. I would suggest that lawyers will be bound by these economic incentives in the mainland, as well as the pressure from clients in the mainland. So in a way, professional bodies is another important battlefield for these activist lawyers to try to contest the leadership in order to regain professional autonomy and integrity as part of the legal system stakeholders. And if we put it in a lens as challenges against colonialism, we can also discover, in my book I explained it, actually all these different forms of resistance are trying to challenge or contest some pre-existing power structures inherited from the British colonial regime and was further enhanced by the new regime after 1997 under the Chinese Communist Party. By promoting public legal education via civil society, actually these lawyers are trying to popularize legal knowledge. In Hong Kong, legal knowledge has always been seen as a privilege exceptional to legal elites who are so proficient in English, who are so proficient in legal technicalities. People have to rely on legal elites to try to survive in the legal system. But this activist lawyer has done is try to make all this legal knowledge accessible, make it vernacular, make it popularized and general for public reception. And this knowledge becomes very important and operational when they have to face arrests or prosecutions when engaging in protests. Providing support for protesters in criminal defense is also another way to unravel the illiberal, unjust criminal justice systems in Hong Kong. That the lawyer realized that Hong Kong's common law is not the English common law system. It is a common law system with colonial characteristics, especially when draconian laws, public order laws, and other forms of laws were still enforced in Hong Kong, and they were not repealed despite Hong Kong has a constitutional document that safeguards fundamental rights. And this is also an eye-opening experience for many of my interviewees as lawyers, as pro bono lawyers in Hong Kong, that they would realize without engaging in this pro bono work, they would not realize the root causes of the unjust criminal justice systems in Hong Kong. And contesting the leaderships in the Law Society and the Bar Association is also to try to contest the pre-existing power structure between the colonial regime and those professional bodies, as they were seen always as a collaborative colonial power. And in post-colonial times, this power structure remained and continue. And there's no true independent bodies that could govern the legal professional community without the state control. And this is embedded as all the regulations for the legal community decided by the state authorities, and the state authority is ultimately not democratically elected. These are the examples of how this critical minority of activist lawyers try to engage in civil society empowerment. They will engage in protests. They set up groups that will focus on promoting the rule of law ideas in Hong Kong society. And they also set up workshops and trainings for people who attend criminal trials in support for political activists. These are kind of basic legal knowledge for dummies. Like if you got arrested, what you could do, what the police could do, what the police could not do is something you can find on Instagram in ACLU nowadays, right? So it's more like a popularizing legal knowledge in the past. The reasons why these lawyers would set up these initiatives, as one of my interviewees explained it, it's difficult to change the orientation of the existing professional bodies. So their work is important because they could represent a liberal and progressive voices of the legal profession, even though legal professional bodies may have many obstacles to be progressive or to be liberal, and they may have to be more conservative, fitting in order not to be targeted by the government authorities. And when they engage, criminally arrest the protesters, for example, in the 2014 Occupy movement or in the 2019 anti-extradition movement in Hong Kong, they were also able to mobilize lawyers, to allocate them to different police stations, to visit those arrestees, to give them legal advice, to witness this arrestee giving testimonies to the police. And quite often, through this experience, they were also able to realize the importance of democratizing not the legal community but also the whole society. Picking up cases related to protests will give you much less income because I must spend lots of time and energy tackling them. This is an interviewee who used to work on non-contentious legal work. She is mainly a civil and commercial lawyer, to put it in a simple way. Moreover, I must draw up on cases thoroughly as I feel I own them. If I could not perform due diligence when defending them at court, how could I defend the proud reputation of the rule of law? So for them, it's engaging in this protest movement as professionals is caused by their sense of guilt and grievance that they could not be part of the movement as professionals. Because in 2019, there were many protesters who tried to resist the government passage of a law that could allow the authorities to extradite people from Hong Kong to mainland for trials. And these lawyers felt that this is the only way that they could help them, to help the protesters and to uphold the robustness of the criminal justice system. And last but not least is to engage in elections in the professional communities. The main reasons of why these people will engage is they saw there's a need to try to rebuild the reputation of the Law Society or one of the professional bodies in Hong Kong, that they have been silent when the government executive authorities were so active in jeopardizing the public understanding of the rule of law and the practices of fair treatment against citizens. These were the lessons, the experience of Hong Kong lawyers in resisting the Chinese regime in the past decade. Now we are in 2025. It's 5 years after China imposed a national security law on Hong Kong. And how did it work in terms of resisting legal imposition or legal transplantation? It is a gloomy picture because after the national security law was imposed based on facts and based on legal cases, more than 300 citizens from activist sector, from professional sectors and journalists, scholars, etc. They got arrested for different national security crimes. And in Hong Kong's national security laws, national security was broadly defined. That could cover speech-related crimes, association-related crimes, peaceful activities, and the courts in Hong Kong have also affirmed the use of the national security law was constitutional and legitimate, and even the court would argue the use of national security law was necessary, as we have found in the past few years. But of course, for many observers, some rights-based advocates, we would say the national security law is really undermining fundamental rights and freedoms of citizens. How does the resistance have continued so far? I mentioned there are three methods of resistance in Hong Kong in the past decades: to challenge the hegemonic legal knowledge, to challenge the illiberal criminal justice system, and to challenge the pre-existing power structure within the legal professional community. All of these words are now facing huge obstacles because, on the one hand, following the imposition of national security law, the Hong Kong government also initiated a citywide propaganda on national security education, trying to replace our rights-based legal education with a more security-based education, meaning that for the sake of safeguarding national security, fundamental rights and freedoms are no longer fundamental. They could be compromised, they could be prevailed by the needs of national security. I guess this is also a global phenomenon, not just in Hong Kong, but it happens ever since 2001. On the other hand, the illiberal criminal justice system continues to be effective against political activists in Hong Kong. There are many political trials happened in the past 5 years, and there are still trials ongoing under the law that political activists could be sentenced to life in jail if the court finds they should deserve a maximum penalty for engaging in activities that threaten the national security of China. And the pre-existing power structure is further securitized, and the law society and the bar association in Hong Kong became more conservative, mainly because of the imposition of the national security law that creates sense of chill and fear that professional bodies will no longer able to make independent voices, especially on state-sensitive matters. I can give you one example. In 2021 and 2022, before the Law Society's elections, the Hong Kong government made clear statements that if the professional community did not make good use of their vote to choose their new council members, the government may eventually consider whether the professional bodies should continue to have their own power to give licenses to qualify lawyers on their own. Meaning that if these professional bodies did not behave, that the government would revoke their power for self-regulations. So this is a kind of intimidations that were also reported in newspapers, but eventually that created a sense of chill among the community that eventually they could only elect those more state-adjacent and conservative lawyers as part of their representatives, the professional council. If so, does it seem that my book is too outdated, or does it seem that legal resistance is over in Hong Kong? I would say not yet. After the 2014 umbrella movement, many observers and stakeholders in Hong Kong would say Hong Kong's democratic movement has come to an end, because after the 2014 umbrella movement, Beijing did not respond to the popular demand for universal suffrage, and the political reform was rejected by lawmakers. And it seems since then the whole society in Hong Kong become much more silent, much more frustrated in political affairs, and many of them have retreated from public engagement. But just 5 years after, in 2019, Hong Kong there was another movement started off in Hong Kong. There's the anti-extradition protest. Then millions of citizens went on streets protesting peacefully against the government's proposal for China extradition. And there are many citizens adopting different tactics, ranging from peaceful to militant tactics, to try to create pressures for the government to withdraw the bill, etc. So we never know how would a movement go, especially if we look at social movement literatures. Social movement has a cycle. There are times for climax for a movement, but there are also times for appearance of a movement. And in terms of resisting these pre-existing power structures, ranging from in terms of legal knowledge, in terms of the criminal justice system, and in terms of the leadership contestation, there are still some seeds of resistance in Hong Kong. For example, there are still many initiatives in Hong Kong to try to popularize legal knowledge. They will do court journalism every day to try to transmit what's happening in political trials to the general public with objective facts, without judgment, and to let people to think critically of how these criminal trials is going. And there are also political activists who are trying to challenge the legitimacy of the criminal justice systems. They are not simply defending these criminal cases based on legal technicality, meaning that they are not fighting for a case for the purpose of getting them acquitted. They want to challenge a public understanding of the legitimacy of the court, to challenge the legitimacy of the existing legal system, where this is something desirable by the general public when we were so inspired by ideas of democratization in the past. And there were also many initiatives overseas or transnational initiatives to try to support the legal community in Hong Kong by showing that disapproval of some illiberal practices or unprofessional practices. One example was really about the recent disbarment of Hong Kong former lawyer Kelvin Yam. He was imposed a bounty warrant by the Hong Kong government, and after that, the Law Society of Hong Kong disbarred him as a solicitor in Hong Kong because they accused Mr. Yam of making statements in the US Congress asking the US Congress to sanction judges and prosecutors in Hong Kong. After that official announcement of Mr. Yam's disbarment, there were at least 8 international organizations made a joint statement in support of Mr. Yam and asked the Law Society and the Hong Kong government to withdraw the decision of disbarment. And among these organizations, they are not simply human rights NGOs. They are not simply advocates. Some of them are the Law Society in the UK, lawyers associations in Canada, and the International Bar Association, etc. So it's not just human rights advocates, activists showing solidarity and support for legal professionals, but also legal professional bodies from other common law jurisdictions are also trying to show support. So I guess this is another trajectory, especially following the Hong Kong's trajectory of developing so-called diaspora movement, that many Hong Kongers are setting up diaspora communities across the world. This is part of the diaspora movement or transnational movement for Hong Kong's human rights protections, rule of law, and judicial independence. So these are my speculations. I don't have answers whether this would work or this would not work, because there are different constraints, including the Chinese government's use of security laws in an extraterritorial way, as well as the other legal instruments that could enable further intimidations and violations of rights against advocates, legal professionals, both in Hong Kong and outside Hong Kong. But if I may end my slides, I guess this quote was quite powerful to sum up what my book was trying to display. Although it's an academic book, my book also explains how legal professionals are trying to make legal knowledge more accessible to the public. This is a way to mobilize the public understanding and public support for liberal and pro-democracy conceptions of the rule of law. And eventually, there was also a key to, in many instances in historical context, popular support, bottom-up solidarity is very important for decolonization movements in many former colonies. As I mentioned at the very beginning, Hong Kong has undergone British colonization, but after 1997, it seems the political and legal structure remain as in the colonial times. Although there are new instruments to support Hong Kong to be more rights-respecting, but ultimately, without changing the power structure, the power equilibrium, it's difficult to uphold this rights-based approach to governing Hong Kong and to upholding Hong Kong as an open and free society. And if I may end my presentation with this quote, given by one of the co-founders of a civil association founded by lawyers, and this was a public quote, it's in a media interview. The interpretation of law should not be the preserve of the selected few. Rather, it ought to be something accessible and comprehensible to all. And I guess this is one of the missions that a Hong Kong lawyer has been doing. And I'm sure, and there will be more professional scholars, journalists will continue to make the knowledge of Hong Kong more accessible to you all. Thank you.